Good morning and welcome to our last lecture on the Introduction to Law. Today is the 8th lecture of this course, and today we are going to talk about international and national law and its relations. After today, that will be the conclusion of our lecture on the Introduction to Law. And then we are going to continue with international law proper. Introduction to international law proper. Now, today's lecture will be a sort of foundation to our follow-up lecture on international law. What is international law? Let us define international law textually. International law pertaining to the relationship between nations, a political state. Law, body of rules flowing from enactment or customs, regarded as binding. Therefore, textually, international law is the body of rules flowing from formal enactment or from customs pertaining to relationship between political states and regarded as binding on those states. Let me repeat it again. Defining international law textually, international pertaining to the relationship between nations. A nation is a political state. Now, law is a body of rules flowing from enactment or custom which are regarded as binding. Therefore, textually, international law is the body of rules flowing from formal enactment or from custom pertaining to the relationship between political states which are regarded as binding on those states. International law in the broadest sense. In the broadest sense of the definition, international law comprises the quasi-ritualistic habit of behaviors between different people that give some certainty to relationship between these people. Cicero, one external and unchangeable law will be valid for all nations and all times, and there will be one master and ruler, that is God. Complex of legal norms ensuring peaceful existence and continuous development of international community. It's a legal system that binds sovereign states. Let me repeat this again. How can we define international law in the broadest way? Well, we could define it in different ways. One is, international law comprises the quasi-ritualistic habits of behavior between different people that give some certainty to relationships between these people. Secondly, Cicero, one eternal and unchangeable law will be valid for all nations and all times, and there will be one master and ruler, that is God. complex of legal norms ensuring peaceful existence and continuous development of international community. Finally, international law is a legal system that binds sovereign states through treaties, conventions, and any documents both sovereign states signs, making the content binding between them. Laws of nations. The law which has received obligatory force from the will of all nations or of many nations. This was how Brutus sees international law. He sees it as the law of nations. The law which has received obligatory force from the will of all nations or of many nations. International law is also the law of nations and is therefore a system of rules regarded as binding on states in their mutual relationships with each other. International law is also a body of law that increasingly regulates how states act within their zone of traditional sovereign authority. Now, let me summarize what international law is all about. 1. Legislator. It is subject of international law, that is states. States are the legislators in international law. Secondly, principle of sovereign equality. Each state is sovereign and it is prohibited that one state would be subject to power of other states. International law could have coordinative character. In general, the basic principle of international law is what we call in Latin pacta sunt servanda. It means agreement must be respected once signed. Therefore, this is the basic principle of international law. Pacta sunt servanda. Pacts must be respected. That is international law. In fact, now we have defined what international law is all about. Then the next question is, what are the subjects of international law? The subjects of international law could be defined in different ways. 1. Each unit or entity to which has been ability to rights and duties confers, as well as ability to legal act. Some of the subjects of international law, therefore, has to be states or nation. The second subject of international law after state or nation are intergovernmental organizations. The other subject of international law could be special subjects. Now we have listed 3 subjects of international law. 1, the state or nation. international governmental organization, and special subjects. Now, let us deal with these subjects one by one. A state. What makes a state? Or what makes a nation? Now, for a nation to be called a state, or for a state to be called a nation, it has to have three basic elements. One, it must be a sovereign territory, or it must possess a sovereign territory. It must have population, and it must have a sovereign power. Secondly, there are distinct moments that qualifies a nation or a state as a sovereign. The distinct moments could be: one, creation, cessation, separation, association. The other distinct moments could be extinction, separation, conquest, or association. These are the basic elements of states. So let me repeat it again. The three basic elements of a state is or are: 1, territory; 2, population; 3, sovereign power. And the distinct moments that a state has or could have are creation, succession, separation, association, extinction, separation, conquest, or association. Now, let's talk about international organizations. International organization could be governmental or non-governmental. Governmental international organizations are associations of states that, on basis of legal acts, that is, on the basis of international treaty, provides certain activities for its members. Secondly, their subjectivity has to be derived from its member states and is limited by the scope of its existence. Let me repeat it again. Governmental international organizations are associations of states that, on basis of legal act, that is, on basis of international treaty, provides certain activities for its members. Their subjectivity is derived from its member states and is limited by the scope of its existence. When an organization has all these qualities, then they could be termed as a governmental international organization. For example, the United Nations, the WTO, or the World Health Organization. Now, which international organizations are then non-governmental organizations? Non-governmental international organizations are associations of private entities. but possesses no international legal subjectivity at all. So, non-governmental international organizations are associations of private entities which possesses no international legal subjectivity at all. These are what we call non-governmental international organizations because they are formed by private entities and they have no international legal subjectivity at all. Now, which international organization do we then consider as special subjects? Yes, some international organizations got this title as special subjects. Organizations like International Committee of Red Cross, International Cities, Sovereign Military Hospitaller, Order of St. John of Jerusalem, of Rhodes, and of Malta, and of course, the Holy See, the Vatican. These are considered as special subjects under international law. They don't have the quality to be a state. They don't have the quality to be a governmental international organization. They don't have the quality to be a non-governmental international organization. That was why they were accorded this or recognized as special subjects under international law. So let me name them again, these organizations that has these special subjects under international law. The Red Cross, the International Cities, the Holy See, which is the Vatican, or the Sovereign Military Hospital, Order of St. John's of Jerusalem, of Rhodes, and of Malta. If you have been to Vatican or to Switzerland, these are the kind of military you see guarding the palace of the Pope or guiding the Swiss territory. So they got this special subjects title under international law. Now, how do we see individuals under international law? We individuals are generally not regarded as subjects of international law. They may be recipients or objects. They could be protected because of human rights and the increased number of rights guaranteed to individuals by international law. So individuals generally are not regarded as subjects of international law, but they receive a lot of protections as objects via their country or their nation, and most of the human rights recognized by the international organizations were recognized in order for individuals to be protected in whatever is going on in the international sphere. Therefore, individuals are not regarded as subjects of international law, although they are protected under international law. Now, sources of law. Article 38, paragraph 1 of the Statutes of International Court of Justice. The court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply a international convention, whether general or particular, establishing rules expressly recognized by the contesting states. B. International custom as evidence of general practices accepted as law. C. The general principle of law recognized by civilized nations. D. Judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rule of law. You see, one of the sources of international law is what I just quoted, Article 38, paragraph 1 of the Statutes of International Court of Justice. Relationship between international and national legal system. Now, we have monism and we have dualism. In monism, there is only one law and one legal system that has multi-level structure and composed of many subsystems. 1. Monism with supremacy of international law. Monism with supremacy of national law. Supremacy means legal power of the subsystem in mutual relationship. Are we making sense? Let me repeat the relationship between national and international legal system again. In a monist system, there is only one law and one legal system that has multi-level structure and composed of many subsystems. In monism, with supremacy of international law, there is monism with supremacy of national law. Supremacy means legal power of the subsystem in mutual relationship. Now, the second one is dualism. Dualism are two separate legal systems, international and national. Penetration of one to the other is possible only on the basis of explicit acceptance of the other legal system. Implementation. Implementation of norms of international law equals method how to make international law norms legally binding in the domestic law. Is it getting complicated? Let me repeat again what dualism means. Dualism means two separate legal systems, international and national law. However, penetration of one to the other is possible only on the basis of explicit acceptance of the other legal system implementation. It is also possible only by implementation of norms of international law. Equals methods how to make international norms legally binding in the domestic law. Three sentences describing rule of law. 1. What is rule of law? How could we describe rule of law? Well, individual may do whatever is not prohibited by law. State is allowed to do only what is explicitly entitled by the law. To limit rights and impose duties on individual is possible only by law or on its basis. These three sentences describes what we call rule of law. It is a bit confusing, so let me repeat it again. The three sentences that could describe rule of law are: 1. That individuals may do whatever is not prohibited by law. And 2. The state is allowed to only do what is explicitly entitled by the law. And also, to limit rights and impose duties on individual is possible only by the law or on its basis. These three sentences describes what rule of law is all about. How do we implement this? Method of implementation. Implementation norms. Norms set up framework for implementation of international law. You cannot implement international law if norms are not set up in a form of framework. Therefore, there are 4 methods of implementation of international law in the national law. 1. International law could be transformed into national law. It could be incorporated into national law. It could be adopted into national law, or it could be adapted into national law. So, when asked what are the methods or the 4 methods of implementation of international law into national law, you could tell them that the 4 methods of implementation of international law to national law are: 1. By transformation, 2. By incorporation, 3. By adoption, 4. By adaptation or adaptation. Let me now explain to you what these methods mean one by one. We talked about transformation. International norms is adopted as statutes of the state. Result: 1. 2 independent norms. No connection between the 2 of them. Each of them has separate development. Therefore, when a nation signs treaty, then the parliament will change, we enact a status to be able to transform that treaty into the domestic or national norms so that domestic law and that treaty will be the same. That is transformation. Now, incorporation. International law or international norms has on the basis of implementation norm procured power of domestic norm. So when international norm has on the basis of implementation norm procured power of domestic norms, result will be that international norm will be directly applicable and directly binding both in international law and in domestic law. So once the international norm is implemented or incorporated into the national law, automatically it bonds with the national law and it becomes one. Now, adoption. International norms is implemented by the state according to its goal, not according to its structure and content. That is adoption. So when a state wants to adopt an international norm, the international norm is implemented by that state according to the purpose or goal, but not according to its structure and content. The result would be the independent and different norms. They are not identical in content. They are identical to goals. They have their development. So when it is adopted, gradually it will start forming part of the national or domestic law. That is adoption. Then adaptation. International norms is applied in practice, that is, constitute legal customs. Domestic courts applies legal customs as source of law. The result could be independent and different norms, common according to content. They have separate development. Now, I know this is a very complicated situation, but all these processes goes when it comes to international law being applied in the national law to make it workable. So it has to undergo any of these processes that I just mentioned, depending on if the country is a monist state or a dualist state. Okay, now let's talk about the legal status of European Union. I decided to put this here in this lecture because eventually we are going to talk about introduction to European law. And the European Union has emerged in the last decade as a new system of international law. That is why it is important to briefly enlighten you about the legal status of the European Union. European Union was established by a series of international treaties. One, the treaty establishing European Coal and Steel Community, which happened after the Second World War. It has now expired. Another treaty was created, treaty establishing European Community, which has now expired. Then Euratom was also created, which has now expired. There is also the Single European Act, which laid foundation, solid foundation, better foundation for what we call today the European Union. Now, there is also Treaty on European Union, which officially created what we have today as European Union. There is Amsterdam Treaty, which was a treaty that made some additions and subtractions of what was initially created that was not working, or that was working but not working strongly. So the Treaty of Amsterdam took care of that. There was also Treaty of Nice, which continued to modify all these 4 or 5 treaties that I mentioned above. And there was the last treaty, which was the Lisbon Treaty, which helped to still make the status of European Union much more stronger and functional than it was before the Treaty of Amsterdam. So the legal status of the European Union consists of treaty establishing European coal and steel, treaty establishing European Community, the Euratom Treaty, the Single European Act, the Treaty on European Union, the Amsterdam Treaty, the Treaty of Nice, and the Lisbon Treaty. Pre-Lisbon status. European Community has 4 goals pre-Lisbon status. The 4 goals was the interior legislation, single market, single currency, and free movement. Later, common foreign and security policy was introduced, which foresees the rapid development of the Union. And also, there was cooperation in justice and home affairs, like the Schengen system you hear, or the Europol. After Lisbon Treaty, European Community and European Union merged in one subject, European Union that is subject of international law. 2 things happened. There was a strict distinction between powers of the EU, powers of member states, and shared powers. This was what the Lisbon Treaty established. So after the Lisbon Treaty, there was a distinction between the powers of the EU, between the powers of the EU member states, and the powers to be shared by the member states and the EU. All 3 pillars included into the scheme, and further, no differences in policies from various pillars. The European Community for Atomic Energy, Euratom, was also established, or strongly established, by the Lisbon Treaty. Legislative. In the European Union, their legislative processes are divided into 4 or 5 processes. The regulation, which are generally binding, and they are directly applicable. I will talk about the direct effects or directly applicable effects of the regulations when I will be talking about the European law. Now I'm just telling you how their legislative processes goes. So, in European Union, regulations are generally binding. Each member state must oblige to regulations. It is directly applicable. There is also directives. Directives binds member states. However, they need to be transposed into the national law. It is directly applicable as sanction results to the state that fails to transpose it. So directives are binding to member states. They have to transpose it into the national law, and it becomes directly applicable. And if a state fails to follow the directives, they will be fined. Then decisions. Decisions are binding only to parties. They may be sources of jurisprudence. There is also recommendations, although recommendations are not legally binding. Then there is also opinion, which are also not legally binding. The details of these legislative processes in the European Union, I will lecture you on when I teach Introduction to European Law. This should be the end of the lecture on Introduction to Law. At least we covered what criminal law is all about, what civil law is all about, what international law is all about, and now what European law is all about. Take your time, listen to this once, twice, and the third time to be able to download in your system what makes sense out of this lecture. My name is Gabriel. I'm a lawyer, and I'm here to assist you make good grades in your first year, especially in Introduction to Law, or Introduction to International Law, or Introduction to European Law. I'll stop here today, and I meet you next week when we start our first lecture on Introduction to International Law. Thank you and have a nice day.